Amen, and thank you. All right, colleagues, thanks for coming. We try to go to wend the way through the rest of this, the matrix for this bill we need to take through. We did get a little delay, but for good reason. You're aware that the first meeting I skipped was because we're giving some room to Minister Grange to get I think the Sexual Offences Act, right, AG, at a nearer stage because of an issue which has been hanging for a long time.
Right,
but
DPM.
So our own problems are one which we have to keep at, get the legislation in order in dealing with our criminal violence issue. We have a long agenda which we're fighting our way through with the support of the various departments, AG and legal reform. So this is just one of them. Zones of special operation has proven to be quite effective. It is cannot be applied as widely as we would like it because of the budgetary costs, and we don't want to dilute the program either. So we have to use it literally by example, deliver more for the year, and then as we build out, extend it, but we'll have to take additional action in the other areas where the crime gets over. But let us make an attempt to at least perfect this particular act. I gather last week we stopped at 15, but there are some questions emerging in 1 or 2 before I run into 16. Can you remind me of them? And I think AG wasn't with us last week either, so we're good to have her opinion on this. I guess there was a comment was Anila, can you point them out? Oh.
Minister, I know there were some concerns about 12 and then 13, 14, and 15 would come from 12 as well. I know that the CPC was also asked to provide some way in which it could be reworded, section 12 that is. With us today also, Minister, I'm not sure if you wanted to have that now.
Yeah, officers.
We have some visitors with us.
Yeah, it's not usual, but I gather because these questions were raised on section 12, we invited Ms. White from the legal department of the police force to be present at me, and we can have her answer any question that we cannot settle ourselves here in relation to the matter and then make a decision. So what was the fundamental issue on 12? Can you indicate to me, Anelia, and any of the members, Senator Sinclair, or you're here, or go and point out to me what was the questions on section 12? Senators?
Minister,
yeah.
When we're looking at 12, because there was a recommendation that from the JCF, I believe it was, was requesting that it become an offense if there was a breach of the curfew. And we were looking at aspects of it. We had checked the, we had checked the Constabulary Force Act, and we were able to confirm that it was not an offense in the Constabulary Force Act. There were issues that were raised as to what the possible penalty should be for a breach of the curfew or cordon, which was also an issue, and we had some differences. Some persons were of the view that, and I believe Member Jackson had suggested that it should be 500,000, and I had submitted that it should be $1 million, keeping in sync with what is contained in the Disaster Risk Management Act for breach of the curfew, because I can't see what would be a difference in a person breaching a curfew in one legislation, just to maintain consistency.
Okay, so the issue then is it would have to be written into the new law that it is an offense to breach the curfew in the zone. That's the penalty. Right.
Well, I think probably it should be more than that, because it is not an offense in the Constabulary Force Act.
So it had to be.
It would have to be in this and also a consequential amendment.
Okay. Well, that seems pretty straightforward. We didn't have any we could proceed along those lines on that one. But the fines, we have to be consistent.
I know there's an issue about the consequence amendment. Sorry, Minister. The consequence amendment of the constabulary.
Yes,
I don't think we'd agree to that.
That is.
Members, sentence it clear. And there's also the question of the form to be used to declare any such curfew. That I recall to be part of the discussion on why the CPC was to go back and look at and to bring to us proposals as to the way we may make the legislation reflective of that discourse that we had.
And the forms to declare a curfew are pretty standard. We need to vary them from for the zones, AG. But the forms
but also the question, the communication of the fact that a curfew was in place and so forth.
In a zone.
CPM, I'm just working on a little technical challenge for joining, so I'm listening, but just pardon.
All right, we are hearing you though. Yeah, hear it clear now. Let me get that clear. That there is, well, if you're the zone in terms of announcing that there's a curfew, which lasts 48 hours initially, they have to use the standard 48 hours. How do you communicate that to them?
I think that was part of it, as well as to declare, to demark the, because within a zone, you could have a curfew to demark and declare the boundaries of the zone. How would persons be able to be aware? And I think it was clear that you would not inform of a curfew before it is declared, because you would not want people, or cordon, because you would not want persons to escape that dragnet. But once it is declared and in place, how would you ensure that there are clear demarcations of the boundary? Because there was a concern raised by Senator Brown that if that were not so, then what we were discussing in respect to the penalty may create difficult situation for persons if they are not certain and then they inadvertently breach the cordon or curfew.
So you get
also believe that Senator Brown had an issue as to the drafting of the section to say that there should be mens rea and it should not be a strict liability offense. I think those were some of the issues.
It should not be a
strict liability offense.
You mean it?
If you breach
you mean you could avoid, you could do without a fine, or you would make it a discretionary activity. So I don't understand.
The strict liabilities, Minister, that it matters not what your reason for going out. You're going to the maternity, you're going to deliver a baby.
So you make it a...
So that, in other words, did you knowingly breach it? Did you have a reason that the judge would say, well, in such a situation, I don't consider it a breach?
Right, so you're saying...
Yes.
So you're allowing some discretion, flexibility in the process. If the person can give up genuine...
Yeah. Not at the point of sentencing, but at the point of the offense being committed. Yeah.
And
I don't know. Is that reasonable?
But we had indicated, because in a normal curfew situation, there is a ground commander who can give
discretion,
permission to move within or outside the bounds of a curfew. So if there, the example given by Senator Brown is one that I am certain that a ground commander would not oppose.
So generally, where the curfew is declared, I agree with the view that it must be announced so persons would know that they are required to stay indoors within certain hours. So the general prescription would be that between the hours of X and Y, all persons are required to be indoor. And anyone who is found to be outside without reasonable cause or reasonable excuse, that is when the offense could be created. And that would take it away from being anyone outside without more during the declared curfew hours committing an offense. It would be anyone who would be outside without reasonable cause, or you know,
that's the normal thing.
Something along that line.
But when we're doing the call and search curfew, AJ, we don't know the announce it. You put up the checkpoints and then it's an indicator that.
So, Chairman, we have to have regard to what security operations are designed to achieve.
Right.
Sometimes you have to do sting operations. Sometimes you have to do it unannounced in order to achieve the goals. But all times there is a requirement for fairness, particularly procedural fairness in dealing with persons. And there has to be reasonable cause for activities, because reasonable cause is the antidote to arbitrariness. And our laws do not at all authorize arbitrary action under any circumstance.
So they need
I missed the AG last week because that's the exact point we were making. Thank you, AG.
Lambert. All right.
Yeah.
I see you know, Leon by AG, you know. All right. No more. No, yes, but I'm just saying the zone, to have a curfew in a zone would indicate something special is happening. So it should have to be looked at in that context, AD. So as I said, the operational nature would have to be defined. I would expect in a zone of special operation that something had to happen specifically, because the zone is already defined and have regulation that is designed to maintain good order.
Bear in mind also, DPM colleagues, that when we're talking about security measures in a zone, we're not talking about ordinary policing. We're talking about enhanced measures and enhanced activities, not the regular run-of-the-mill activities. But I think from experience, we have found that when the zones continue over a period of time, it may move from the enhanced policing activities to the regular policing activities. And I think that is why we would be looking to separate out the security operation side from the community development and build out side of it.
All right, so the recommendation here is that we can have a curfew in a zone of special operations, but it will require no consequential amendment. If we put in this law, we'll have to have a consequential amendment to the JCF Act if we're going to make a penalty for those who breach the curfew. Is that in layman terms the understanding?
No, because we are agreed that there should be, and there's already in clause 12, the imposition of curfew in the zone.
Right.
And that there's no problem with that. The issue was, how do we treat the offenses? And the proposal was that the CPC should provide us with some drafts as to how we deal with that. I don't know that we were agreed that we would extend this to the wider society in terms of the adding to the Constabulary Force Act, the issue of breach of curfew. There's obstruction of police in the performance of their duty and such issue, and I believe the public defender was opposed to this. That's part of the dialogue we had the last time. I believe Senator Sinclair and Senator Golden would recall.
All right, what entails then the regular curfew, Senator Sinclair? Yeah, we have a few of them down here now. I mean, usually it's designed to get in there and identify or at least quell activists, criminals fighting each other and apprehend them by virtue of.
Yes, yes, that is so. But, I mean, if we were to make it an offense for breaching a curfew, why is it just going to be restricted to the ZOSO legislation? That it is an offense there, but it is not an offense right across the board, which I believe the JSF, that was the JSF's recommendation. So that is the issue. I just prefer it because I can't see what's the difference in a curfew under disaster risk which is a national legislation applied nationally. And you're going to, in respect to security, and you need a curfew, and a person breaches the curfew, the only area that you will have it as an offense would be under the ZOSO legislation within the zone.
Member Sinclair, Chairman, it is permissible to say that where you are rolling out enhanced measures, special measures, acts done in those locale and for those period would be treated a little differently from circumstances where regular activities are taking place. But I believe what you are querying would reflect a better approach to take, that where a curfew is declared as a matter of policy to be translated into law, and the curfew is breached without reasonable grounds, reasonable excuse, then it becomes an offense, so that we understand that when persons are required to stay indoor, it has to be for good and compelling reason, because your own safety and your own well-being is at stake. And the general approach would be for persons, unless there's really good reason for you to be outside, and that you have to provide and it has to be assessed. So I would agree with you that to the extent that we are moving to make it an offense for someone to disregard curfew once declared without reasonable grounds, then it should be done generally wherever and whenever a curfew is declared. And right now we do have it under the DRMA orders. So
yeah, at Senator Brown, I'd urge we agree on it. I like to have our thing. I'll tell you why. Go beyond the legal structure that both AG and Senator Sinclair outlined. To be practical, two ways. One, in terms of announcing it, all our police vehicles that are built to come with public announcements. So and usually curfews are in small areas, you can announce them over a microphone quite effectively. And they reach everybody. Secondly, there is, given what's emerging with whatever happens, in the state of emergency as a tool, there'll be the issue of violence in communities will be around for us for some time, and there's increasing use of limited extraordinary, and the curfew is really an extraordinary measure above ordinary policing. And there is generally a tendency, not a matter of policy, I'm saying, but there'll be a greater tendency by the police force to use curfews before you get into the mode of establishing a zone which is costly, or a state of public emergency once the Constitution is settled. So it gives you an effective second step before you get into the third and fourth step. And because I think this is one of the challenges that emerge with the state of emergency, that some review it as you're going to the ultimate level very fast. It may be possible if we strengthen the Curfew Act, make some sense that you can use in a selected small zone very quickly before the matter grows out of proportion, and you have to look at more severe measures. And that's how it's being used now in the curfew guys in very small areas.
I recall somebody cautioning us last week that the remit of this Joint Select Committee was to review this legislation, and if we wanted to look at consequential amendments to other legislation, we'd have to come and make a report. And then that goes to cabinet, yes.
Okay,
so
fair enough. Okay.
I don't want to rehash the issues of last time.
All right.
Sadly,
fair enough.
Minister,
I
have
hear
a
what you're saying.
judicial matter to deal with now. So I'm going to take my leave, and as soon as I finish it, I'll try and rejoin. So my apology for leaving, and I hope that Senator Scott Matley will join the other members of the committee soon. So
I think Member Paul
last week.
Member Paul have equal legal skills.
No. Greater. All right. My apologies. I'll try and rejoin before the evening is out.
All right. Good. Yeah, what I detect from Senator Brown is saying process. Let's approve the amendment to the ZOSO, and you make a report and we indicate a consequential amendment that would have to come from cabinet for the JCF Act.
So
is that the approach process?
I foresee this part of the recommendation saying that the committee has agreed for a recommendation for the creation of offense for the breach of curfew were declared, and that the recommendation should be carried through to whichever legislation under which, not limited to the ZOSO legislation, but extended to wherever a curfew is declared.
Yeah.
Yes.
All right. Okay. And then next, so that would take care of the required changes from 12, 13, and 14, Anita.
If I may,
Senator Golding, go ahead. Senator Golding.
I seem to recall too that we were cautioned in relation to extending to other pieces of legislation based on the remit and mandate of this committee. I just wonder if we could confirm and double check.
This is what I got from Senator Brown, that while we agreed to have it included here, the final decision would have to await the report going to cabinet to make a recommendation to extend it to all of the areas.
Yeah.
It's not a decision, so.
Okay.
So we go straight to 16 now, I think. We covered 15 last week, together 16. And I remember that the police is here to answer any. While it's not usual, we thought for clarification if there needs to be some. Arrest or detection. Section 16. Yeah.
Was there
any dispute? I don't know.
There's a recommendation. I'm just looking at the recommendation.
Yeah. There's a small clarification from the police to change under the act to in the zone. That would seem to be just a tidying up activity.
We just have the recommendation enlarged on the screen, please. Possible.
Yeah. Could you go? Can we get all the recommendation? Anita, you're posting. Go up a little bit. We're just seeing half of it now on the screen. Please, who's controlling the screen? Anila. We'd like to see a bit more of the recommendation for 16.
I'm sorry, sir, it's not me today, it's Mr. Richards, and that's
Mr. Richards.
He's trying.
Okay. $16 has a number of recommendations. There's first from the Jamaica Defense Force. Which is Amendment to section 16.1 to allow for the commander. Can I get any more on this on the screen? Oh, all right. Any comments there, AG? Senators and legal light, Philip?
Let me take off my mask. It don't look so. Never mind. Just tell me.
SG, I'm seeing you there.
Sorry, Chair. Yes, the AG is with me, but we're just having another discussion.
Yes.
We're in a side
Never
meeting.
mind.
Sorry.
I don't have an issue.
Okay, we can move on. 16 is being accepted, what we see there, the issues. It's good. Senator Sinclair, you have that concern?
The Jamaica Defense Force recommendation doesn't seem to be offensive.
No, it said they give the prior to JSC, which is reasonable.
Yes, but they wanted the removal of the reference to 12.1.
Right.
Yeah. What they are saying.
So that's fine.
In essence, they would have the power to arrest and detain throughout the zone, regardless of whether there's a curfew or cordon established.
Yes.
All right. If you are satisfied, we can look at.
I pretty much agreed with most of the recommendations from the JCF. So if you don't hear me say anything, I'm fine.
All right. We can then move to 17 then and take the recommendations. On the 16 is accepted. AG. 17 is about persons held in custody.
Yes. The AG is on her way. Give her a minute, Chair.
Okay.
Sorry about this.
Well, we have acceptance.
Thanks for your patience.
That's all right. We have one acceptance. SG, you can comment if there's any concern. I'd expect you to read it. For 16, we have agreed to the amendments there.
Sorry, Chairman, there was a comment from the public defender, which is not being considered by the committee.
What was that comment?
It's on the screen, sir.
Oh, well, I don't know if there's a reference to it in the reports. I know that they have JPs or turning that is to ensure we have JPs. I think what this was where at one stage there was ours in the Antigua, and the justice peace should be one with a lay magistrate, and they were asked to make it a justice of the peace. But they always think they're justice of the peace. I'm not sure this comment.
Sorry, Chairman, I'm trying to decipher the comment. In addition, there is no reference.
It's not a legal, but it's not to do with the amendment or any amendment. He's saying there's no reference in the report to implying of those who are detained going to a JP. But that's, as far as I'm aware, they're all usually taken before a JP for warrants to be signed off and etc.
So we have to distinguish between
amendments
alleged to be an administrative omission where a provision is in law, or I need to amend the law. It does appear to me that is that the law provides for one thing, but they have not been able to get the record of it.
Well, yeah, which is an administrative issue.
Right, yes.
It's an administrative issue.
But we would just say that where the law specifies that an action is to be done, we continue to encourage the officers on that responsibility is placed to comply.
Yeah, but that's within the report. Okay, it doesn't require an amendment to the law. Section 17 now, Mr. Richards.
Excuse me, Chair, sorry to disturb, just to verify that you had the committee accepted both recommendations for 16 from JDF
Yeah.
and okay.
Yeah, that is the station. Section 17, person held in custody, proposed consequential amendment to Section 17(1) of this act, of the act with the current time period of 12 hours being amended to 48 hours.
So just to say, while we contemplate, Chairman, I mean, we have moved our jurisdiction in a particular direction with the Charter of Rights, and every effort is being made by the government as we get a better understanding of how the courts are interpreting what the legislature has provided for to have compliance. My own approach is that we always bear in mind steps that must be taken and do not legislate in a way that will make it put the state in breach instead of compliance. And so if a time period is really not reasonably practicable for acts to be done, then we don't, simply because there is a clamoring, legislate when for all intents and purposes we're going to put the state in breach. That is my general approach. So we bear in mind that many times it's not the simplest of case, but you also have to look at what will happen when you're dealing with multiple defendants, multiple complexity factors.
So we accept the 48 hours. That's not reasonable because, as you said, AG, we must make the legislation practical in the process, essentially. Oh, really?
Mr. Minister?
Go ahead, Mr. Jackson.
Thank you. Regarding that period from 12 to 48 hours, I have a bit of reservation about that. I heard the AG's point about the practicality of processing within the time. But, you know, what detains my mind is the fact that if somebody is detained and we presume them to be innocent, an extended period, you know, can be a bit. While I'll accept that 12 hours might be a bit short, but I think it's a big leap to go from 12 hours to 48 hours. So I want to suggest if we can arrive at a compromise of 24 hours. Because I try to put myself in that position. I want to be detained for 2 days without, I would find it grossly unfair. But I say I'm accepting the practicality of it too, especially as she said, you have a multiplicity of defendants or detainees. But I think it's a big leap from 12 to 20 to 48.
You know, Member Jackson, if the logic of your argument is to be taken to its conclusion, then there would be no action taken against anyone in light of the presumption of innocence. What the presumption of innocence is really saying is that there are certain guarantees in respect of due process that must take place. I understand and appreciate the concern that you're raising. From 12 to 48 is a huge leap. Could there be something in between that would increase but not necessarily go to that? Perhaps the recommendation, so the recommendation is an amendment that the current time period of 24 hours being amended to 48 if the above amendment to section 16, and that is a person held in custody. So we have 24 hours.
The current station is 12. The current time period is 12, which is too short.
Can I just see back the amendment to the 17(1)?
Yeah,
Madam AG, I think we're confusing two issues.
That's what it seemed to me, yes.
The time that a person is held in custody, which currently in the Act at section 16 is 24 hours, a period not exceeding 24 hours. Where the 12 hours comes in is in section 17, where the Act currently provides that it's after 12 hours, a justice of the peace has not made an order under section 16.3, then certain investigations have to be made and the person must at that time be brought before the justice of the peace. So the 12 hours is not in relation to the detention.
Yeah, that's correct.
In custody. It is in relation to the bringing the person before a justice of the peace. So what the security forces are asking is for the 24 hours, the custody period, they expanded from 24 hours to 48 hours.
No, we are. Go ahead.
And if that is so, then under section 17, a consequential amendment to increase that same period of 12 hours to 48 hours. And I'm not necessarily seeing the connection between one and the other.
Yeah, and I think for section 17.1, 48 is going a bit far. I'd agree with Member Jackson on that one. I think we should, despite the pressure, the zones that tend to be smaller and tend to be long-term, not like a quick 1, 2, 3 fix in terms of a state of emergency. You should.
Member Jackson, the to the period, the period of time when it takes to bring the person before the justice of the peace. I just want to say that.
No, you're correct, Senator Rowland, and that is exactly my point. And that I believe that I can understand, as I said earlier on, the 12-hour being might provide some administrative challenges, especially if there are multiple persons being processed at the same time. But to move from 12 hours to 48 is quite a steep jump for the process to click in.
Can I ask a question? 17 is a safeguard to the citizen, right?
Right.
So if an officer takes somebody into custody, they are to be seen by, within 12 hours, they should be, the security forces should get an order from a JP.
Right.
And that would, and it is only if, well, let us say no JP is available. It's in the dead of the night, no JP, they have not gotten a JP in 12 hours. And an assistant superintendent is then tasked to determine what is the reason why he has not seen a JP and to ensure that he is brought before a JP. Because the JP is a person who can declare or have the person remanded for 24 hours under 16, isn't that so? So it is just to ensure that there is some hearing, some opportunity for the person to, circumstances to be looked at to see whether he should be detained for a period, even going up to 24 hours. And that's the purpose of the JP. So I think I can't see why we would be considering changing 17.1 to 48 hours.
Let me get it right, Cynthia. What you're saying to me, 17.1 is saying that a man is detained in Crawford Street,
right,
for whatever reason, by a police officer. So, I said, it's not as the other section where there's reasonable doubt. You find him, man, you have good some reason to detain him, but he should be taken to a JP within a certain time frame to confirm that he can be detained from 24 hours or more.
Right. 16 says that the person should be taken before a justice of the peace, and the officer has 12 hours to do that. If they have not done it, then an assistant superintendent must be informed and he must seek to determine why this person has not seen a JP.
And then proceed to find a JP.
So take the steps to have the person brought before a JP And then the JP can say, having heard the circumstance of his detention, can operate the provision under section 16(2)(b). Sorry, not 16(3), where the JP can now say, you are going to be remanded for 24 hours.
All right, well, amended 16 to go to 48 hours.
Yeah.
But is that a recommendation?
Sorry.
Is that a recommendation?
16(3) is amended to go to 48 hours?
I think that's what's in the recommendation too. Most of the things in 16 are extended to 48 hours. But to take him for a JP, we would need to amend it to do that, because you would be allowing the police to detain him for 48 hours without seeing the JP, which would be a different ball game. I'd have to agree with keeping section 17.
I think section 17 should remain. So the JP can remand the person for 48 hours under 16.
Yeah, I think all of those have been amended to give some more time.
Okay.
But
after the 48 hours, they go before a parish court.
I'd expect that.
Under 16. But I do believe that there should be some protection to the citizen. And that is what 17, I believe, is seeking to give.
Excuse me.
Yeah, go ahead.
Sorry, Senator. Ms. White is trying to explain, I think, her hand has been raised.
Okay.
Hi, good afternoon. Am I being heard?
Yes, you're being heard this way. Go ahead.
Hi, afternoon, Mr. Chairman and your members. Right, in order to understand what the JSC proposed in relation to section 17, we have to go back to what we proposed in section 16. So in essence, what we had proposed in section 16 was an extension of the time periods for detention. So currently under the Act, the person must forthwith be taken before a justice of the peace. And the justice of the peace is limited to extending the person's detention to 24 hours. And then after that 24 hours, the person has to be taken to a parish court. And our submissions were in essence to increase the time periods. So what we had submitted was that the person should be taken, instead of being taken before a justice of the peace forthwith, because we had submitted that is actually restricting our usual powers. For example, under the Bail Act, we have 24 hours to take a person before a justice of the peace. So this legislation, which requires us to take a person forthwith, is actually decreasing what we usually are empowered to do. So we had made those points in our submissions to support a proposal of extensions of the timeline. So I could take you to the proposed extensions. So the first proposed, and I don't know if you and your members have our submissions, because I don't think all the submissions could be captured on the, or are properly captured on the spreadsheet. But the first proposal that we had made was for the person to be taken before a member of the JCF designated in writing by the Commissioner of Police. So in essence, it be taken before the Joint Command, a member of the Joint Command, right, which is a person that is of no less rank of superintendent, within 24 hours, and that this officer would be required to review the arrest and detention to ensure that there are reasonable grounds to suspect that the person is committing or is about to commit an offense. And in the circumstances that they are so satisfied, they shall have the power to remand the person for a further 24 hours. We then went on to propose that if it is that the person is remanded for a further 24 hours, the person must be taken before a justice of the peace at the expiration of this further 24 hours, and the justice of the peace is required to review the circumstances of the arrest and satisfy him or herself that there are reasonable grounds. And we had proposed that if it is that the justice of the peace is so satisfied that he or she should have the power to further remand the person for a period not exceeding 72 hours. That is our proposal. And then after that, the person must be taken before a judge of the parish court. So that is why the proposed amendment to 17 is 48 hours, because in the proposed amendment to 16, the person would now have to be taken before the JP within 48 hours.
Good afternoon, Chairman. This is Nadine Wilkins from the LRD. May I
yes,
something?
Go ahead.
Thank you, sir. I'm listening to what Ms. White is saying, but what is happening is Ms. White is referring to the existing outside of a ZOSO Act situation where the act of arresting and detaining an individual is within the context of that person being suspected of committing an offense. The ZOSO is not structured that way. It speaks of reasonable ground for the arrest or detention of the person. So it's not that strict situation. So there may be myriad situations that in the judgment of the officer, there is reason to detain an individual. And I think that is the reason why provision is made for that person to be brought to an impartial third person forthwith.
Sorry, just to clarify, it is a part of our recommendation that the power of arrest would be for reasonable grounds that the person has committed, is committing, or is about to commit an offense. That is in our recommendation.
But you already have that. That's already the law. That's already the case. If those conditions exist, you already have the power to arrest that individual. ZOSO Act or no ZOSO Act.
Correct, but the procedure under the ZOSO Act is different, which is what we're trying to address. So if it is that a person is arrested in a ZOSO because there's reasonable cause to suspect that the person is about to commit an offense, the current procedure we are saying should be amended in keeping with the proposal. That is what we're submitting. So we're not saying that you can just take up and arrest people. Of course, you're going to arrest them in accordance with what obtains, which is if there are reasonable suspicion of committing about to commit. But the ZOSO, this current regime in ZOSO imposes an authorized stricter requirement for those circumstances.
Let me see if I can.
It's supposed to be extending.
Before you come in, Minister.
No, I want a little clarification I ask, because what I'm getting from the comments from Ms. Wilkins is that the term reasonable suspicion in the ZOSO is a lower level than what is used for the general law to arrest in the wider circumstances. Am I right?
Or detain.
Or detain. So if it's a lower level, then you will put short the time to go to the JP, because it means...
This is it. This is allowing you to not necessarily have to suspect that this person is committing or has committed, but there may be a set of circumstances that suggest to the officer that, we need to take in this person. And the fact though is that because you have to go to this impartial third person, you have to show them what are the factors that would inform you and say to you that you need to detain this individual. And I believe
hold on there though, ladies. It's always worth reminding that regardless of what is happening on the land, you have to have reasonable grounds to interfere with the liberty of someone. All right, so the operations, and I said it before, that is the antidote to arbitrariness. So I'm not so sure, Nadine, I wasn't hearing clearly what you were saying.
What I'm getting, AG, is that Nadine is saying that reasonable grounds is at a lower level. While there has reasonable grounds, it is lower level than what is in the general law, which speaks of having suspicion of being involved in some activity. The term she may quote, you know, the
but
legal
those
term.
are just two different ways of saying the same thing. That you would suspect that you reasonably suspect that someone has committed an offense or is a
I have to be advised on that.
Or is in the
your internet went out.
Different ways.
Your speaker is going on.
Reasonable. I'm not sure what the bone of contention is.
It's not a candidate. As I said, the impression I'm getting, well, Ms. Wilkins may speak on it. Ms. White is seeking to bring the two things in line. In other words, whatever is done beyond the zone is at least maintained in the zone. That's my understanding. So you'd amend 16 to reflect that in the same circumstance. In other words, 48 hours before you go to JP.
The police are reminded that you're not stripped of your general policing powers because you're in a zone, you know. It's that and more. So I don't know if some confusion is coming from that and the belief that a police cannot, because the powers of the constable are the powers of the constable.
Madam AG,
only that
we are saying that we are restricted when it in relation to the detention regime. We are more restricted, right? In the zone as it is now, we are more restricted than our usual police powers.
And that greater restriction comes from what?
The time frame in which you have to get
of detention.
My age as a lay person.
You're pointing to? I'm just looking.
Yes, section.
It suggests 12. Right. Go ahead, Ms. White.
And section 16(2) and 3. Because what the regime provides under this act is for the person to be taken forthwith before a JP. Under the normal circumstances, we can take the person within 24 hours before the JP. That's one. And this regime also says that the JP can only remand up to 24 hours. And under the normal circumstances, the Bail Act does not impose any strict timelines in that regard. So we had proposed a regime with timelines, but that those timelines be extended from what they currently are in the Act. Because I am not aware that the ZOSO Act gives us other powers of arrest and detention. To me, we can only arrest and detain someone if there's reasonable cause that they're committing or about to commit an offense. So I don't know that the ZOSO Act gives us something special to lower that standard. So we're saying in keeping with that, this is the proposed regime that we are asking for because the current regime restricts us than what is normally provided for in the Bail Act.
I hear Ms. AG, if your comments.
Sorry, I'm just not able to check. We'd have to just check back to see what had informed the time difference. No. But to the extent that just assuming that it is correct that there is a difference in time frame, I can appreciate the problem that is being pointed out. I'm not able to just check. So the recommendation would be to make the provisions under the ZOSO consistent with the general provision under the Bail Act. It is the broad thrust of the recommendation.
Well, Madam AG, we were actually asking to make it, to give us a longer time period in light of the fact that this is supposed to be a special act where we have additional powers. But we're making the point that...
But it shouldn't be any lower than what is generally provided for. The ask would...
Well,
for greater time, having regard to all of the circumstances and special operations, but at a minimum, it shouldn't be less than what is generally provided for.
Yeah.
We were
right. If that is the ask, Miss White, then I would have no difficulty with it. I think we will have to. SG, can you just remind me what was the rationale for that difference in time frame? Remind the committee, please. Through you, Chairman.
Sorry, I would have to check AG, but I don't think I think the recommendation is for more time. Not that I think it's for more time.
No, but the recommendation, AG, I don't hear me better than some of this the internet here. The recommendation is to make it consistent and give a little more time, which after 24 hours, they'll have an assistant, a superintendent would have to examine the case and see if it's justified for the 24 hours before you find the JP. If there's any circumstances that is causing an impairment to getting to a JP, the superintendent will do the assessment for the additional 24 hours. The point Ms. Wilkins will make, and Ms. Wilkins, you could intervene and clarify for the AG, is that the term reasonable doubt was of a lower level than what was in the general law. And if it was, then therefore you should have a different regime. I got from the AG that it was saying the same thing in a different manner. And if it is the same thing, then I guess the recommendation from the JSC as accepted by most of the committee members should proceed. And therefore, what to the matter is in 17 is how we align 17 with 16.
Can I ask?
Send us in clear, yeah.
The Bail Act, because I hear reference being made to the Bail Act. The Bail Act speaks to when a person is charged, right? And the person is given an opportunity to have his matter heard to determine the issue of bail.
Sorry, Senator Sinclair, it is section 22 of the Bail Act which speaks to where a person has not been charged.
Sorry, 22?
Yes, Senator.
Well,
sorry, Senator, just to remind everyone, if you're not having internet challenges, please turn on your cameras. Live on TV as well as PBCJ's platform, social media platforms. Thank you.
Okay. So you want the platform, you want the cameras on?
Yes, Minister.
The problem is the cameras tend to disrupt the internet. It needs a wider bandwidth when they have the cameras on. That's why I turned off mine a while ago.
I follow you this way. 22 gives you a 24-hour period, right?
Yes, Senator.
Yeah.
Where the person has not been charged.
Not charged.
Which is why we had to refer to it.
So what she's asking for on the ZOSO, Senator, is that with the support of the intervening of a superintendent of police in the ZOSO, they get an additional 24 hours before they get the hearing. So the superintendent would be acting, expect to act in a higher level of responsibility, review the circumstances and see that there is good reason to continue detention until they get to a JP.
Why is there a concern that you can't locate a JP within the ZOSO, or not within the ZOSO, a justice of the peace, and would have to rely on a, so why can't we find a justice of the peace with so many being appointed and trained and so forth? Just to quick have the person's matter heard before an independent person other than the superintendent or assistant superintendent.
If I chairman, I just want to enjoin Senator Sinclair on that point, which is exactly my thinking. I would believe that in the setting up of a zone of special operation, that the security forces would at least avail themselves of a list of JPs that are accessible, knowing very well that the need for those services are likely to arise during the course of their operation. So there is opportunity to properly equip themselves with such personnel in easy access.
In principle, I agree, but I think from a practical point of view, let's say, the ZOSO has what we call 3 phases, and I expect some discretion to be used by the leadership. In the first phase, when you're talking about the security clear phase, where you're intervening because there is a genuine security risk which is higher than normal, I think it not be unreasonable to ask even that first, especially those first 7 days when there's increased activity and therefore there could be increased. If you're going there and there increased number and you have done it right, you're going to be detaining an increasing number of personnel. You could maybe need more time to deal with to get to a JP. You know, if you are busy moving around in truck, ensuring you apprehend the members of the gangs that you're looking for, it could be a significant number of people and may take some time. Once you get into a near normal situation, then the normal JCF power should remain, which is 24 hours, as indicated. So I think that's really where your dilemma approval. I don't think there should be any undue cause in the first phase. But I guess you cannot make the law into phases in this case. But I would think the request by the JCF that, you know, especially in the first phase, then you need you may need a little more time, but it would have to be approved by a senior officer of the police force. I don't know, Mr. Jackson fits, you see, because it's really, you're giving the police some extra tools to deal with what is considered a critical situation, which is above the normal. And what is requested here is an additional 24 hours over the normal 24 hours. It doesn't seem unreasonable in the first phase of the operation. If it goes beyond that first phase, then it could become, when you're dealing again with the odd person, it certainly could become abusive. But in that first week, it may be a necessity in terms of the practicality of the operation. And the objective is to get in there and identify and screen, not only find those who have been challenging, but it allows you to engage those who provide a risk which will not risk the child. And, you know, once you begin to engage them, then you can direct them somewhere else as well, which is to direct them to the social programs. But you need time to sort out in that first phase the number of people you're dealing with, and an extra 24 hours should not be, I don't think it's content abuse. In fact, it is giving you an opportunity to deal with them in a more effective way.
Well,
I don't know.
My point, Chairman, is just simply specifically 17.1, right? Which, and I think Senator Charles had made the point very clear, that you're going to be detaining, so the justice, well, you're going to be detaining a person for, I want to detain them for some time, for information which you have or whatever the circumstances might dictate. The intention of the 12-hour is to make sure that there is some third party in the mix.
No, it says, it's effective, it says forthwith, you know, in 16.1.
Forthwith, yes.
Right. But I'm saying the regular police action allows you 24 hours before you have to go to a third party. Now, what the police have said, in the phase, you're going to a zone because it's extraordinary circumstances, and they may have a case where they want to go beyond the 24 hours, and you'll not be able to move as agilely to justice of the peace because you're going to a era which demands extra detention, extra person. It requires, you need extra time to settle the situation. But before you do so, you don't get to a JP, you have to go to an officer of the force, which is a superintendent. Therefore, you need that level of response. And then, but even the superintendent will only have 24 hours, that they must determine why and record it, why they would have kept him further, and then get to the JP. However, ensure he gets to a JP within the 24 hours, which is why the 48 hours come here. It doesn't seem to be unreasonable in a clear situation we're going into. I mean, we're not going into a normal situation. We're going into a specific situation agreed to by the director of the security forces and, well, recommended by them. And that's the determining factor, that we have extraordinary problems. And as I said, it is an activity that doesn't rise to the level of requiring a state of public emergency, but requires some extra powers. And all the aspect 24 hours extra, which must be given, and I expect a superintendent to be giving responsible and good reason, not just arbitrary taking anybody off the street and locking them up.
Let me start from a back-end, Minister, because you rightly said that you would not be legislating in phases. So the zone would be operated for an extended period.
Right.
So in crafting this particular section that speaks to the powers of arrest within the zone, you're commenting wanting to give or to exclude the JP and to have the superintendent extend the time. You're focused on the front end,
right?
The clear section, but there's nothing that changes. It can remain right throughout the period of time, even when you get beyond the clear stage. From my own practical experience, I always, even for the perception of it, prefer that when we're speaking about somebody's liberty, that if we can have an independent person, body, determine an extended period of time for one's detention, is something that I think is more palatable to me. And I suspect will be more palatable to the majority of persons. So I would not be offended to see an extension having regard to the comments made, that it's 12 hours in section 17.1 be extended to 24 hours to have a JP. And as Member Jackson said, going into a zone, and as we have a very proactive Minister of Justice and custodies across the island that are increasing in numbers of justices of the peace that are available and the quality of the justices of the peace that are available, I can, in my good conscience, go beyond the 24 hours. And I would not want to rely on an assistant superintendent to determine.
And assistant superintendent.
Superintendent.
You have an assistant or deputy.
Or a superintendent for that matter. And I'm speaking from practical experience. The squad mentality runs right through the Jamaica Constabulary Force. So, as I said, from a point of view of in perception, I would prefer to see a 24-hour period. I think that is more than sufficient time for a justice of the peace to be able to assess, regardless of the circumstances, because if a person is arrested in a tense zone, if you had a cordon, if you had a curfew within the zone and going at particular targets, when you detain them, first of all, they are going to be there for a period of time until they are removed, because if they are going at, say, 10 targets and they caught 1, 2, 3, they don't take them out individually, you know. They will continue their operation until they are removed. So they may be with the security forces in a particular area for a particular period of time. So when you work it out, they are going to be in custody for even a longer period than 24 hours. But then when they are taken out and placed in the appropriate lockup, which is outside of the, if I can use this term for brevity and in quotation marks, combat zone, the hot area that is being targeted. some other person is dealing with that, the person back up. And like your situation could not be assessed within 24 hours to find a JP to assess it.
All right. Any JP or lay magistrate?
Well, in another section of the act, we spoke about the lay magistrates and so forth. Well, if it is lay magistrates, that too, because they would be, as Member Jackson said, appropriately informed as to who the available persons are.
All right. So
Chairman, may I just point though to Member Sinclair, 17.1 flows from 16.3.
Yeah.
So the time period in 17.1 is to say, if you get to the halfway mark and a justice of the peace has not made an order, then this is what is to flow from it. So you would have to construe 17.1 in relation to what 16.3 says. So any decision in relation to 16.3 would impact 17.1.
What I understand, Ms. Wilkins, is that if we go with sentencing recommendation, which is why I asked for a lay magistrate and not just a JP, if you go with 17.1 to 24 hours, then you'd eliminate 16.3 altogether. 16, the amendment that gave the assistance.
Well, 16 would have gone to 48, which is what Ms. White had been.
Yes. Yeah, Ms. White saying, so you'd really, remember, Ms. White have a structure, you know. You're detained for 24 hours. At the end of 24 hours, if they do not have the order, they go to an assistant superintendent to examine why the person has seen the JP, and then they would have keep him for further 24 hours and ensure that he's seen by a JP. What sentencing is saying, remove the assistant superintendent, because the officer who detained him at the very beginning, maybe very well the commander-in-chief, the joint commander.
Yes, so, and I concur with that view as well.
If that is so, you will just remove that second amendment, Ms. White, which, so although we have gone through it, we'll go back and remove it. The 16, the second recommendation, it would remain the person detained for 24 hours, and then they recommended to see a JP who can then recommend that they detained for 72 hours. Is that 72?
72 or 48?
48, Chair.
So I think the recommendation in this case, I think in 16, after peace remand the person for a further period, not exceeding 72 hours. That was the recommendation that the JP, in the case of the zone, could recommend them for 72 hours. And I support that.
Yes.
All right. So
that you eliminate the assistant superintendent, but you keep the 72 hours and you insist on a lay magistrate for 16.
So 16.2b about the forthwith. The forthwith would be removed.
Yeah.
Would be removed.
Right.
And what you'll get now is 16 rational will be removed and replaced by the person was taken before the member of the before the following.
And then beyond that, now the person is taken before a parish court judge to determine. Yeah.
At the end of 24 hours.
Yeah. When it will be end of 72 plus 24. It must be considered.
So these are the orders that the GP is empowered to make in 16.
Right.
And if they don't make that order in 17.1, 17.1 is making a provision for what is to happen.
Well, we need an adjustment. In 17.1?
Yeah.
17.1 would have to be appropriate.
Yeah. It will go to 24 hours.
17.1 would start with 24 hours.
Mm-hmm.
Yes. Yes. And then,
excuse me, Senator, Miss Simon from LRD has had her hand up for a while. I think she still wants to say something.
Miss Simon, I'm not seeing the hand here, so go ahead, Miss Simon. My apologies. Okay. I'm not seeing the hand on my screen. I'm not seeing the screen.
Okay, sorry, Minister. It was just some concerns with regards to the timelines that are being proposed. we think that the 72 hours is a bit long, even though we understand that there is a need for more time. So the forthwith that is used in 16 and 17 may be a bit short, but we think that it should be at least, to keep it consistent with the Bail Act, then that 24 hours would be more suitable. We don't think that the tiered scheme that is being proposed for Section 16 should be adopted.
Well, I take your point, but remember, we are going beyond the Bail Act in this particular situation now.
I understand.
We're going to zone a special operation where we request not extraordinary, but some special powers to ensure that the police can do an effective job in the clear phase without getting overwhelming in the bill phase. We will become abusive, so there has to be a compromise somewhere. 24 hours for the JP would be, for limits, would be too short a time. We are dealing with multiple cases and people who are likely to be not serious offenders. The zone is declared already. Violence is erupting. So you're talking about violence producers. It's not just a average. It is specially amended to give the police practical powers to deal with an extraordinary situation without, as I said, getting overwhelming.
Yes, but since 16 is read with 17, so if the 24 hours in 16 adds to whatever time period is in 16 adds to what is in 17.
No, 16 gives 24 hours and then you add.
Right.
Additional, right. And I'm saying that the 16 is the detention, which comes under the JSC Act as well. You can detain for 24 hours before you get to the third party. The third parties would give the 72 hours with the lay magistrate.
Oh, there's a fourth within 16 too. So that was the fourth is that I was speaking about, that I would understand if they wanted to change that to 24 hours, but maybe not as was being proposed.
16, where
they say forthwith before a JP.
No, that's what's being changed to.
The 16 to be forthwith would have, if we're going to be looking at 17 to change it to 24 hours, I think, and having regard to the discussion, 16 to be, the forthwith there would have to be moved, and the person, and it would then be bringing it into sync with what is contained in the Bail Act, where a person is arrested and not charged, they can be brought before a justice of the peace within 24 hours.
Right.
And the justice of the peace can make an order for either release or for further detention. But it does not state a time. It says it can make an order for further detention.
Yeah.
In this,
I would think it might be wiser to leave it open-ended rather than to specify a time. Just in case you run afoul of the Constitution or anything like that. The 72 hours just seems a bit long, so I wouldn't.
Okay, so leave it home to the discretion.
To the determination, depending on the circumstances.
And therefore, if it's a breach, it will be on an individual basis. In other words, they may go 24 hours or 40, but if they go to 72, and the case was unreasonable, they could go to court and get justice. Yeah. All right. But I think that's a reasonable fit.
So sorry, DPM, can you just clarify what
Mr. Samuel is suggesting is that instead of saying that lay magistrate will extend it for 72 hours, you'll leave it open with knowing that the Bail Act will apply generally, but they still have some discretion here to go a bit over 24 hours. If they go too long, then and there's no case, the person will basically go to court to get.
Sorry, but to have no cap at all, DPM.
But
I'm advised.
But you know what? So you may be looking at making a significant amendment to this, then because.
I think you should have some
what
time
would happen, Senator. That's exactly, and I'm not sure that we could support something like that because I'm not sure that the interpretation.
Yes, because you could then put them away for a month. Yes. All right, I'll detain them in Montego Bay for you, AG, SG.
I think that there should be a time.
Sorry, careful how you invoke that Montego Bay DPM, and I know Senator Sinclair is there also, but I have a very vested interest in the Montego Bay area. So.
All right. Make sure. All right. We make sure your father is well protected, SG.
That's why he's pointing out.
Oh, and I forget AG. Sorry, AG. Yes, you also have your vested. I do apologize. There's too many persons with vested interest. But I do have a concern with the open-ended concept.
I agree. I like some. If 72 hours is too fast, we can go 48 hours and then you get the parish code. But on a weekend, there might be a challenge, and that's allowable or not counted.
Sorry, DPM, also AG had asked me to advise. Remember that the Bail Act is also currently under review. So,
right.
You know, there may be an impact from that perspective.
Yeah, there might be some circumstances. But I was going with the 72 hours.
Our perspective from the chambers, and this is why I've been sort of quiet. You know, it's a serious constitutional issue.
Yes.
And a lot rides also on the proposed amendments to the Bail Act as well, to be honest. I
appreciate the concern. This is why, and I take Ms. Someone's concern, but why I suggest that the JP being viewed should be a lay magistrate, and then I don't know, outside of the zones, it can be any JP, but that gives them the additional powers to go up to 72 hours, but not beyond that. Something we might be stretching the discretion a bit far. I'm saying, given the nature of what we're dealing with, I'd prefer limitation, Ms. Someone. And I take HSG's comment. I think in the circumstance we're looking at, I think we could take the risk with 72 hours. That was the maximum I think they're allowed before.
Chairman, is the recommendation for the 16.1 to be specific to situations where the person to be arrested or detained is suspected of having committed an offense? That language, that change will be there. So these areas that we're discussing will be in that context.
Yeah.
Okay. Just check.
And I said, and I want to lay magistrates with the person they go to right after the 24 hours, who would then allow some extra time. I know we're stretching it, but I think we should stay with the 72 hours until we see what the Bail Act brings and if we have any challenges.
72 hours sounds inordinate.
That's not long. That's 3 days. So you cover a weekend if you get a weekend.
But don't we have a
48? With 17 might be better.
What's that? No.
I was just saying that since it's read with 17, that maybe the 48 might be better. Because it's 48 plus what, 24 for 17? That would be 72.
That's she's talking about 16.3b. Would say at the expiration of a period of 48 hours.
Mm-hmm.
And then that adds to 17.
It's another 24 hours.
So that makes 72. So I don't know if we need to go to 72 then.
Let me get there. I'm technically impaired here now. Tell me, what is I saying? It would take 16.3.
If 16 is 48. And then you have 24 in 17.1, you're at 72.
So, but yeah, adding them, they can be added or they are concurrent. What is it?
I
think 16 is when they're detained.
Running in between, running concurrent.
17, in fact, 17 comes after 16, in the sense that 48 hours is what they, or 70 is what the lay magistrate doing, but 17 is one thing. No, there will be inconsistency if you have 17 and 48 hours, 24 hours.
17 can only go to that if you're going to change 16.3.
Okay, it probably would be concurrent, but I think 48 still just seems more safe, for lack of a better word.
No, not safe. We have reservations. I accept my legal of it. It's safe, and my police instinct say I want practical.
But what are we going to? Let us just take it.
I'm trying to get it.
If a person is arrested,
in
ZOSO, and I won't. I'm not coming down. Let's just deal with the time.
Right.
The police arresting a person.
Or detain them.
Detains a person. Arrest, detain. They have 24 hours
to get into a JP.
That person before a JP.
Right.
When that person reaches to a JP, the JP can say, having heard the circumstances, etc., etc.
Recording stopped.
I'm going to, hello?
Yeah, that was us.
Right, okay. I am going to remind you.
Recording in progress.
Going to remind you for a further 48 hours? Or is it that you are saying 72 hours?
Yeah, this is, if we extend 16.3, we'd have to say 72 hours.
Why is it that you would be?
No. Well, it's the JP that does it.
Right, the JP. So you're saying that the JP has the authority to extend the remand by 72 hours. So technically, the person can be in custody for 4 days because there is a 1 day period before he gets to the JP.
Right.
And then the JP makes the order for remand for 72 hours.
Yeah, but 17 on remain at 24 hours too for the JP.
Yes. So 17.
Yes, so the person could be put in here. The person could be detained for 4 days.
And then
after, and the remit of a JP.
Right. When you actually work it out, it's going to be 4 days. It potentially can be 4 days.
Yeah.
Right. And then after that period, you're saying that
it must be a parish court.
They have to be taken before a parish court judge. Is that? And then
that's what
the parish court judge will make an order for charge or release.
Yep.
Is that?
Well, charge and hold or release.
Right.
I guess.
Exactly.
Yeah, that's basically how it is structured, you know, if we accept the 72 hours by the day magistrate.
Right. So if we go back now to 16, if we go back now to 16.2b, where we have the term forthwith used in that provision, then forthwith would have to be taken out.
Yeah, that's what the change is, to make it 24 hours.
Right. Which would be consistent with 17.1.
Right.
All right.
The concern by the Ms. Salmon was that 72 hours is too long for a day magistrate.
I'm
suggesting that given
Ms. Salmon too,
the circumstances.
Let me tell you that, Minister, 1 day in a lockup is not an easy lockup.
Chairman, I was about to say the same thing, that I recall someone who had been detained in a ZOSO scenario saying he lost his job because by the time he was released, he had not been to work for that specific period of time and was deemed to have walked off the job. So please think of those things when we're setting these time periods, sir.
No, we have to think of both sides. I said, you know, I like the one to this. The one is what is fair, one is practical, and sometimes the practicality of the station is I'm very aware of those circumstances with Wilkins, where we have had the state of detention in Montego Bay for a long time, and that individuals can do the job. The question is finding a balance, quite frankly, because there are circumstances where it's challenging for the, well, maybe I'm the wrong person thinking there. You know, they have to put together the case adequately to convince the judge that they can hold them. 4 days versus 3 days. All right, let's work with it with the 48 hours. So you end up with 3 days in custody, and then have to see a parish court after that. And I expect the parish court are accessible, that easy accessible. You're a trial lawyer, Senator.
Well, put it this way, you know that magistrates will sit on weekends to hear matters. It can be requested. I would stick with the 48 hours, to be honest with you, in respect to the JP.
In the normal circumstances, what the JP does is another 24 hours as well. So they're getting an extra 24 hours here.
There is no limit.
Sorry, DPM, can I just ask that if the committees agreed to extend, that the rationale is just again provided for the record? Again, I'm speaking from another hat where just in case there is a challenge or something that we know, we understand the rationale, the proper rationale for such an extension, please.
Not positive. I agree with that. So my personal agreeing, as I said, it was that we are dealing with an extraordinary situation that provides practical challenges. And if you are dealing with large numbers in the clear phase and the police need to detain a gang, he has to take time to go through and be able to put his, well, they have to do the work before they have much in life. You're not going to consolidate your case clearly until they have done the detention. While you know that the following ABCD from, Zando gang need to be detained, you end up with 15, 20 people. It takes them time to make sure they can make a case, and they'll have to release some of them in the 24 hours anyway. So there's that, I'm basically trying to balance giving the police the appropriate strength to deal with what can be a very serious situation. At the same time, do not lead to a situation where they are unnecessarily abused. That's the balance I'm trying to find and recommend to you. I know you have to do it in a strictly legal way, and therefore it is going to be challengeable. And you like to lose, we shouldn't pursue it, but
SG, if I may ask, what is being proposed in respect to this, the 24 hours under 17 and the 48 hours under?
Same 17,
under
essentially.
16. No, 16, where we speak to the 48 hours, 16.3a. It's not any different from basically what is in the Bail Act. The only difference is that the Bail Act does not say a time that the order of the JP can be made for.
But the Bail Act leaves it open.
The Bail Act leaves it open, and this is saying that if after that 48 hours they are not released, they must go to a parish court judge.
Yes, understood. It's just that, there are cases that have indicated what judges have found to be too long. And we have cases dealing with upwards of 3 days. So I just wanted it for the record.
Right.
I'm not saying it's wrong or right. And again, it's because of how we have to interpret the Constitution. So I just wanted to have the rationale on the record.
That's reasonable, yes. And nothing. And I said my thinking, as opposed to the legal thinking, which looks at precedents and how judges operate, and saying I'm looking at the side of how the practicality of it in what could be a high violence area in the first few days. So I'm not wedded to it either, Ms. White, you're here, but it seems the common grouping is, there seems to be a greater support, that unanimous on us that 48 hours by the JP and then get to a parish judge. Is that what the bail holds now. Senator Sinclair and Guerra say, when they said the JP has an open mandate.
Under 22, as was referred to by Ms. White, I had looked at it. It spoke to 24 hours.
Okay, so under 22, the JP have to take them before the court within 24 hours, unless there are other circumstances. I mean, so they have to ID.
JP or yes,
unless they are formally charged.
Yes, without charge. They
right.
have to be taken before.
Okay, all right. So what we are saying, they take 48 hours under this. All right, I think we'll stick with 48 hours. Because if the case is strong enough, then charge them and go to, I don't know, 24 hours give them more time to find charges that are binding. We'll set with the JP in 48 hours, 17. After they see them, the JP is allowed 48 to detain them for further 48 hours. All right. And 17 would go to 24 hours. Is that agreed?
I'm in agreement with it, Minister.
All right.
And I'm fine.
Okay. So we can move to, there's a further recommendation in 17, which is more
excuse me, Minister, sorry, before
editorial.
I run on to 17, I'm so sorry. 16.4 on the page that Mr. Richards was on, there is a recommendation to add the words correctional office, correctional center to the list of places. I'm not sure the committee had seen that one. Or agreed on it.
They would accepted that before, in the very beginning. Okay. Yeah. And in the 17, there's to change the word station there to appropriate records.
Sorry, Chair, I'm just clarifying if by correctional center we mean correctional institution as defined in the Correctional Institution Act.
Okay, all right. We'll take the guidance. Thank you very much. The end of 17.1, there's also a proposal that station diary be changed to appropriate records. That is also in keeping with the move to go to electronic diaries in the police stations in short order. We can then take section 18. Again, this is just editorial, station diary to appropriate records. That's not an issue. Any other recommendation there?
Well, Chair, I'm just querying based on the rationale for the proposed amendment to section 17 to change reference to station diary to approve record.
Right.
There's nothing now that would prevent a station diary being kept in a digitized form. And if what is being referred to here is the station diary only, that is the term that could be kept anyway, because if the reference to a term such as appropriate record would really widen it. So if it is station diary that is intended, we should keep that term and nothing in there. Because of the Electronic Transactions Act, nothing would prevent a station diary from being kept in electronic form.
I'd be advised, I don't know. I mean, station diary become to be known as this, the big book in the station, as a kind of generic term for a book, whereas this new station record management system will have similar data, but will be, well, essentially the same data, but it's not a diary really. It's more, it's a record of all that happens at the station, along with other. Well, there are three facets to it. The record system, the station management system, which keeps all the record data of everything that comes through the front as usual. And then there's an asset management and a case management And that will be part of a whole system. So I don't know if legally you'd still be bound to use the term station diary for that. It might be. I think that's why they recommend the appropriate record.
Well, appropriate record doesn't really speak to what that record is or what the requirements are for that particular record. I would gather that a station diary is speaks to a specific content.
I'd be advised if that's your reading at the in the comment, Ms. White there in the, are you, any other police officers on?
Right, afternoon again. Right, the rationale is for the reasons you outlined, Mr. Chairman, that, in the traditional sense, a station diary has a particular meaning. While I appreciate that there is no definition, but out of an abundance of caution, since we are changing the advertised format, and it's not going to be in a station diary, we thought out of an abundance of caution, we would have appropriate records. And appropriate records, of course, the records are as appropriate. There are certain requirements for what records should be kept. So we thought that appropriate records would be sufficient to determine where that data should be captured.
Without a definition, though, it becomes ambiguous. That's the point.
DPM, if I might, I think I have to support the CPC on the point, because the station diary, as we are discussing it, seems to be limited in our minds to a paper diary, and there's nothing, as I know it, in law that limits it at this point to a paper record. Appropriate record then leaves the propriety of those records in the discussion of the JCF. And what we are talking about is that station diary, whether paper or electronic, which contains particular information and in which particular information is recorded. So I am minded to observe the advice of the CPC.
Well, it should not be either or, the station record system will be the definite, will be the system of maintaining all records. There will be no book at the state. If they have a book, then no, they have to go into the station record system for it to be accepted. But on this one, I said a little bit, I'll have to take the legal advice. What's one to be assured is that once you put in place the digital system, there'll be no question as to, up to the records as kept there. And since it's not far away, I don't want to have to come back and adjust the law.
Minister, if I may, it's here.
Yeah, man, I'm here. Go ahead.
I not a lawyer myself, but just from a layman, what the CPC said makes sense, because when I read it, what came to mind is the rollout of the pilots that you spoke about in Parliament, for the electronic form to replace the big book. It would mean that the law would have to be changed before even those pilots would have any validity. But as I say, I don't see the station diary have any specific definition of being a hardcover paper base.
No, I'm advising that, and I respect, I take my CPC's advice. It's a little weird, the kind of challenge we get sometimes out on the field.
If I may, though, DPM, again, to support now what has been said by CPC and Senator Golden Campbell, people seem to forget the Electronic Transactions Act that has been around.
That's what I was saying. She mentioned that. That's
the Electronic Transactions Act was passed, enacted exactly for something just like this. So there would be no doubt about whether or not the big books would be an issue, because it does allow for the big books to also be accepted when it's done electronically. So it's really not an issue legally, DPM, with respect.
All right. We take advice, so we don't need to make the amendments. The use of the word station diary is adequate to apply to digitize records in the future. 18, but it's the same thing, so we can move on. Why is safety and security, we change to security and safety? Why that?
Mr. I think 18, when you said it's the same thing, I believe you're referring to 18.1, which speaks about
station diary being stationed to appropriate records.
But there were some other recommendations that relate to 18.3, I believe, was being suggested. And particularly as far as it relates to the use of the term at any time.
18, yeah, that's the next page. I was following sequentially, yeah. 18.3 has further recommendation being proposed that section 18 to be deleted.
I think the critical thing for the JSF, and I also suspect for the JDF, was the use of the term at any time. It says that notwithstanding the provisions of subsection 2, the spouse, partner, family member, etc., shall be permitted to visit at any time a person referred to in that subsection, which is subsection 2 speaks to the person who is detained. But I suppose if you look at 18.2, it says that 18.2, a person who is arrested shall during such times as may be determined by the prescribed officer be allowed such visits as may be permitted having regard to matters of security and safety of persons. But 3 goes on to list the persons who can visit, but it says at any time. And so the at any time seems to be of a concern too.
I think that too. I think except for the doctor, a medical visit at any time.
The attorney.
The rest should be restricted in some.
If I may, DPM.
Defined times.
DPM, if I may, Chair,
sure,
sorry, if I may just guide and remind the committee, although I don't think I really need to do the reminder, but whatever change is being contemplated, so I take the point, but whatever change is being contemplated, we must be reminded of section 14.2a of the Charter of Rights. Any person who is arrested or detained shall have the right to communicate with and be visited by his spouse, partner, or family member, religious counselor, and a medical practitioner of his choice. And that's the wording in the Constitution. It doesn't say at any time,
right.
But I'm just saying whatever change we make, we have to make sure, though, it will not infringe on this right.
But this is why
because we have to be careful about the change that will be made. So I'm just pointing that out.
This is why SGS says that with the medical practitioner, health is critical and with attorney at law, but other persons will have to be defined the times that there is no restriction on the right to visit, but there would be some reasonable time provided on a daily basis by the security forces. Would that satisfy the?
Well, I agree. I suppose there is a concern about the use of the term at any time, in fact.
And can I suggest that maybe you consider not using the term at any time, since that term is not used in the Constitution?
Yes.
I'm not too keen on leaving it on someone else's discretion, even though, yes, technically there will always be a discretion that will be exercised. But if we could just go back to the language in the Constitution, so at any time is not there, and perhaps we shouldn't put it here as well. But I wouldn't want to now insert new language that could potentially infringe your right. I mean, we would have to study that new language. Yes.
If you look at 18.2, it says, a person who is arrested and detained under this part shall, during such times as may be determined by the prescribed officer, be allowed such visits as may be permitted, having regard to matters of security and safety. There are restrictions in 18.2 in the existing legislation, which would then, based on your argument, be inconsistent with the Constitution, or the wording as contained in the Constitution, but it existed in this legislation when it was first passed.
Right, which is why, though, Senator, 3 was worded in that way, which is why 3 then said, notwithstanding what's there in 2, these persons must have access at any time. But I'm still saying, though, since the Constitution doesn't say at any time, I don't know if we really need to say at any time in 18.3.
I'm inclined to accept this. I'm inclined to accept this recommendation.
Yes.
Okay, if you'll take out at any time, there's still some discretion in left there, and if the person abuses it, privilege, then they go to court.
Yes, the only thing is that looking back at how 18.2 reads, and if we change at any time with 18.3, because you see, that was the whole point of putting in, I think, 18.3, which is what Senator Sinclair is trying to point out to me.
That
have to.
If we SG work with this then. If we took out 2 and 3 and reworded it so that it is consistent with what is contained in the Constitution, right? To allow for the person detained, arrested and detained, to be visited by, and you list the named persons that you have there, without making any reference to time or any other type of prescription. But then there are still going to be rules that govern
the facility.
The facility at a particular moment in time. And I mean, that is what exists practically. No.
And not just practically, because I mean, remember, no right is absolute. Yes. And so the point is, what is in the Constitution is still read with 13.2, the reasonable derogation,
yes.
Which does allow for certain strictures to be put in as are allowed in a free and democratic society. So that would still have to be read into this, whatever the provision is, yes. That would still have to be read in. But I see a number of persons have their hand up, so.
Who is next? Whose hand? I'm not seeing any hand from my screen.
Senator Brown and then Member Jackson, Chair.
Okay. We take Senator Brown, who had left us for a while, and I just had Senator Jackson close off. The chairman, the former chairman, can correct the senator.
Chairman, I'm back with you.
Yes, and I'm giving you preference. I said, if you make a mistake, I'll have the member.
And he's my MP too, and he will tell you that in that respect, I am his boss. Because I do the voting. But we are at 18.3 minutes now. And we are talking at any time. It's kind of create some problems, I can see, that we really don't mean at any time, but I think it's fair to say we mean reasonable times.
Well, what the SG suggested, the Constitution doesn't use any language, so just leave it as the Constitution have it.
But I think we want to ensure that what we're looking at here is reasonable time. At some reasonable time. We don't want it necessarily at 11:59 p.m., though 11:59 p.m. maybe based on some development, the spouse, the pastor, the doctor may need to go there. So I don't think we should just close it. We should allow for the subject, for the detainee or the arrested person to get these visits, but at a reasonable time, because I think that's what we really want, and then so that the reasonableness can be determined and be considered after whether or not a denial was against what was reasonable. But if you leave no time there, then it's open to denials becoming the norm. When what we intended here with the legislation is for visitations to be a right.
I hear you. I said I don't think it doesn't harm to follow the guide of removing any qualification. I think what the SG was hinting at is that any qualification can be challenged, and depending on which judge you meet, you may get a ruling. Leaving it without any is less subject to challenge. But I'm not. I mean, that was my thought as well, to provide that it be done with adequate time or reasonable time. But Member Jackson, let me hear what you have.
Yeah, thanks, Chairman. Yes, Senator Brown is my boss. That is on the record and off the record. He's my boss.
I understand how the boss operates. When instructions are given to the boss by the
chairman or after being chairman, it remains the same. So long as that
by the foreman.
But on the point, I think Senator Brown, to a great extent, addressed the point. If my recollection is correct, why that part put in about at any time, notwithstanding the provision in the Charter of Rights, is that we are aware that many times persons are detained and nobody really knows what has happened to them. Is it detention that they are caught in or otherwise?
No, that's when they're locked up, man. Locked up.
No. When somebody don't turn up at home, right? And some other situation which I won't go into now, I've heard of similar cases. So I want to believe one of the reasons why the provision was there is to obviate against those situations where a person gets locked up and no family member is aware. Because let's face it, the doctor won't go and the lawyer won't go to interface with that person unless that the person is missing.
I know you have to. I don't say that.
But on the other hand, I do acknowledge the challenge of the at any time, and that's what Senator Brown spoke of. 11:59 or 11:58, would not be the ideal time. But I'm pleading that we don't just go by the constitutional provision to say they have the right, as the SG has indicated, but provide via reasonable or something. It must be qualified how soon the person should be able to get a visit by a family member. What's the essence of my concern?
Yeah, Member Jackson. So the view then is that we should retain, we should maintain a reasonable time. SG, you have heard the comments by our members. Is that doing any harm to and make it more challengeable?
Chair, I think we're off the cuff. We don't see an issue really with at any reasonable time. Okay. But allow us to tentatively agree. Would just like to study it a little more, and but at this point, we don't really see a legal difficulty with at any reasonable time. because I think that is how the provision would have to be interpreted. But we'd like to just have a little time to perhaps just look at some case law, which usually is what guides us.
Yeah. I mean, what this Constitution is doing is to ensure that those defined persons will have access. And that's why at any time we're left off. And access should, if you deny them access for 2 months, 3 months, the reason becomes by the judge, essentially. If the person abuses that authority, then the judge will decide what is reasonable time. So putting it in there or leaving it out, I don't know, doesn't seem to be a big problem.
Right. So at this point, we don't have an objection, but permit us just to study it, and then if we do see an issue, we would come back to you. We'll
accept it and put it in square brackets, all right?
You have been trained so well, Chair.
Well, I'm an excellent trainer, you see? She's not only has interest in Montego, she's from Montego Bay. That treatment of persons arrested or detained. That's again 18.7.
Sorry, Chair, before we move on, I missed the rationale that was provided for why it was proposed that the word safety and security be switched around. I
didn't discuss that. I didn't think it was, I didn't see any rationale for it.
Well, I was just wondering because as it is, the provision does seem a little bit ambiguous as to whether, well, it's conjunctive. So it seems to be referring to both security of persons and safety of persons.
Yes.
I was just wondering if the intention was to separate the concept of security from persons. So it could be security of property or something else like that.
Where they're just saying put safety and security rather than security and safety. I didn't see the rational turn to their own. I mean,
it seems unclear whether the word persons is intended to qualify both the term security and the term safety. I was wondering if that was the reason.
You mean to turn it around to change the
changing it around wouldn't really solve the problem, but I was that's what the proposal.
The only thing you could do is make this shown as a safety or security. Safety of the person or security of the space, and separate them. But I don't know if it makes them.
Well, it could be better done by paragraphing to just regard to matters of A, security, and B, safety of persons.
Yeah, all right. I'd take that.
Okay.
CPC. It makes it quite clear that you're considering both this individual and the institution.
Yes.
Space. All right. Okay, thank you. So we go to 18 amendments.
I think 18.7.
Yeah.
They wanted that. The JDF was asking for an amendment in 18.7 that to exclude reference to joint force and to refer to persons who are responsible for the supervision of police lockups or correctional facilities. And I suspect the persons who are members of the joint force may not necessarily be at the place where the person is being detained.
Yeah, but they should be authorized officer should be named, right? That seems reasonable.
Yes.
SG, anybody, any comments on that? That seems a reasonable request. And in fact, it looked like it was more an oversight when it was not there from the beginning.
Well, it may be that we could still leave it as any member of the joint force or authorized officer responsible for supervision of lockup. And why I say that, if a person is detained, arrested, but they are not yet taken to a facility, but they are in the custody of the joint force.
Joint force in the tent or so.
Yes. So I think that we should that do the amendment strictly as they have proposed, but to add other words which would refer to persons who are responsible for the supervision of the lockup. So it may fall in somewhere after any member of the joint force or.
Okay. That's in reasonable. No objection. I'll accept that note today.
Chairman, this provision would cause a member of the joint force to continue to have responsibility for the person who they transferred to that police station or lockup. 7 is suggesting that that is a continued relationship, not that an officer at the police station now is going to be the only person who should exercise this.
Okay, so
I'm saying it shouldn't be either or. I'm saying the continued involvement of the member of the joint force in 7 is a good one. And that I wouldn't want to see it removed.
I wasn't suggesting.
Well, that's no. Senator Sinclair is adding to it that the person at the station still have.
Oh, very well. I beg your pardon. But the person at the station should be required to communicate with the member of the joint force, even if it is not the member of the joint force who has responsibility to take this person to the to get medical attention. I think the responsibility to communicate with a member of the joint force should be retained.
But you're not saying that so you're not saying that the person who would have to communicate with the member of the joint force who would then have to take the person to the facility to a medical attention?
No, Member Sinclair, I'm not saying that.
Okay.
What I'm getting is, I think your addition would cover everything, Senator Sinclair. What I'm getting, legal reform, Ms. Wilkins, is that you add the fact you provide cover for the authorized officer at the lockup, now they move our correctional center. But the officer in charge of that center should keep in touch with the joint force commander since he was first detained by the joint force or the responsible officer in the joint force. Am I right? So if they're moving them to a hospital or they're moving to somewhere else, they'll have to inform their member of the joint force.
That is it.
Fair. Okay.
Well,
that's reasonable.
I'm not just saying about informing. If you go down the provision and the person, where it appears to any member of the joint force, and if we were to add or person with authorized officer responsible for supervision of police lockup, etc., and that person, the person is determined as being ill. I'm not reading it word for word. The member of the joint force or the authorized officer shall without delay. So the responsibility is on both of them. Now, I don't want it to be that you just have a responsibility to communicate to the joint member, which give joint force member, which might give the impression that it is a joint force member that will have to then take them to a medical facility. And either of them.
Agreed. Member Sinclair, agreed.
The problem appeared to me that there's no definition of authorized officer. So if we're going to put in that term or authorized officer, we'll need to define who or what becomes beyond the joint force an authorized officer.
No, it's authorized at the center, you know. Those are defined by already the authorized officer at the correctional center or the other areas of lockups. So they're authorized. They're there by without being. They don't have to repeat it here, Senator. It can be anywhere they're going. It can be just be anywhere they are, but the correctional center or the lockup.
Yeah, but we'll have to define.
No, but there's an authorized officer in charge of a correctional center or a lockup. There's always one.
You mean the superintendent?
No, man, you have somebody in charge of the lockup, would be an inspector or sergeant, depending on the size of the place.
Sorry, Chair, but Senator Brown has a point, because all along this law was only giving responsibility to members of the joint force. But I'm looking at the rationale for the proposal, and it speaks about the fact that, and I'm assuming that this rationale is coming out from practical experience, where persons may not be detained within the zone, and they could actually be detained, for instance, at an an adult correctional
adult correctional center, or
right. So if
or
so
lockup.
the term, so what you are referring to about those authorized persons, they're already defined in those other pieces of legislation. Generally, if someone is in a correctional institution, that act and regs do already provide a responsibility, or they put a responsibility on specific persons to ensure that adequate medical attention is to be provided to what we call inmates, because once you go into a correctional center, you're an inmate under that act, under the Correctional Institutions Act. But it seems as if they want, the proposal is to insert some of that in this law. So we would need to be specific about who we are authorizing under 18.7. So I'm just saying the point that Senator Brown made is correct, that we would need to define whoever we are speaking about.
Sorry, but SG, if we go back to 16.4, which says that where justice of the peace makes an order under subsection 3 in respect to person shall be taken to a police station or lockup without delay, and entry shall be made in the appropriate register. So the detention is as to, and I think we were amending that to include correctional.
Yes, they're adding correctional center
right
to the police station. So that's how they add those areas
right.
with defined.
So although you came in under ZOSO, I believe that if we extended the wording of 18.7 to specifically place also a burden upon the authorized officer, because as it is now written here, it would seem that everything falls on the member of the joint force, although he
is not at the lockup.
The lockup. So
no, I understand that issue, Senator Sinclair. So all I'm saying is, if you're going to expand it, we can't just use the term authorized officer. We'd have to be clear on what is meant by authorized officer.
The authorized officer in charge of
it didn't just use the term authorized officer. It says authorized officer at the police lockup. And when you come back there's no real harm, but when you come back to 16.4, it says the police lockup, etc., and it makes reference to the prison lockup regulations of 1980.
Right. So my concern was more with the correctional institutions. I know you're going to expand 16.4, so I'm just saying we just need to make it clear when doing the amendment to 18.7 who we are referring to for the correctional institution. That's really the issue I was having.
There is no harm in making it very absolutely clear. So
right, yes, especially since we're providing this, it's a responsibility we're providing, we're imposing on someone. So yes, I like to have things very clear.
Absolutely clear.
Because that would mean perhaps, hopefully, one less file in my office.
Senator Senator Sinclair had used that term before when he was speaking to the provision. He had referenced the person in charge of the supervision of persons arrested or detained at the correctional institution. So perhaps.
Oh, and that would be fine. Yes,
that could be used.
That would be good.
But we could just use that. That way, we wouldn't need a definition.
Agreed, and that would be good. So thanks, CPC, and thanks, Senator.
Okay, thank you. Use of body-worn cameras, and we're sending to your call on this, but it's not a practical solution right now. That's the problem. And it's in the law, and I would love to have it there, quite frankly, but it's not practical. We don't have enough body cams, and the uniforms they currently wear don't accommodate body cams in an appropriate manner. We'll have new uniforms soon, redesigned. But all along that body cams, I mean, that's what the channel is with a few body cams that we don't have body cameras, and yeah. So I that's a comment really that we'd love to have them, but we don't have them, and it will take a while to get them. They're reasonably costly, and I think when this was done, it was designed to acquire some in time. It took some time to get the right cameras, and also it involved redesigning uniform, which are not yet changed. So I don't know whether we should delete it or leave it in as an intention. I'd be advised.
You're not proposing, Minister, to take out the body-worn camera?
I'm just saying it's not practical right now because we don't have them, and the uniform they wear cannot accommodate them. We are changing uniforms and we are carrying cameras. Because I'd like to have them as well. It protects the police officer from false accusation. But the attempt was made to introduce them at once, which is why it was put in the law. They say that the stupid cameras, what they had gotten from somebody, wouldn't work in the tropics. Two, the uniform, the way the uniform is designed, they take more the policeman face than anything else. And we had to abandon those, and getting the right cameras took us some time to find, and also it does require redesigning of uniforms, which we are currently doing.
But all I'm trying to find out, Minister, are we leaving it in the law as is until the time comes when we fix it? In other words, you say it's not.
Well, I'd be advised if you have it there, are we come to an offense not to give them, or do we? I'll be advised by the law.
Recommendation from the Federation.
Yeah.
But based on what you're saying, you would not be amending 19.1 as it is written. So the recommendation is not.
Yeah, well, it's not. Yeah, it's not. All right, leave as is then.
Minister, so we're accepting it or we're not accepting?
Can't accept. It's an administrative issue. We can't do it. It's not practical.
Yes, sir. Also, sir, 18.5 from the MNS, from the National Security Ministry. I'm not sure if we actually decided on that proposal.
18.5?
Needed for the term register at 18.5.
What?
Clarity was needed. Go across, Mr. Richardson.
Oh, yes. We're keeping going vertical. Sorry. This is.
I'm not agreeing with it.
Yeah, that's more paperwork, you know. Again, this is the administration. I don't think it's a necessary thing. 18.5 is where we deal with the visits, right?
Yeah.
Yeah. I don't know if I do want to put it near the. When they have the
I don't think that.
So I can just read it deep, Chair, since I can't find it on the screen. It is being proposed. This is a recommendation from MNS it is being proposed that section 18.5 be made less ambiguous. This, as the provision does not outline what particulars ought to be provided. For example, who visited, the purpose of their visit, the length of the visit. Additionally, clarity is being sought as to what is meant by the term register as used in the section. And 18.5 does set particulars of each visit shall be recorded in the
register.
That's what 18.5 says.
When you go to the station, I think that's the station record my system, you know.
But Chair, those particulars and the form of the register seems to me to be something that should be prescribed under the regulation making power rather than set out.
Yeah, administrative. And it could be useful. I don't think it need to be in the law. I agree with that, CP. So 19, as to the body worn cameras, we can't accept that. No, but we leave it in law.
Sorry, just excuse me though, Chair. If it's going to be prescribed, is it that we would want to amend 18.5 to say the particulars shall be recorded in the appropriate register as prescribed? Is that the position?
I'd be advised if that's appropriate.
Chair, if I may jump in here, what is the current practice?
I suspect, well, I don't know. What do you see at the detention centers? Center Sinclair, we have looked at it. I suspect they will take the name and it may vary with each because they know prescribed form may vary from upstairs to upstairs, and from center and from ZOSO to ZOSO. But I have not been there. I think what.
I'll ask the question because you said
that's why MLS is recommending some lack of ambiguity because each center, each zone may be using a different form, and that's, as I said, recording different, beyond the name, they record different information. Mr. Richard is on. Are you aware of the rationale for this?
And Chair, just to expand on Senator Golden Campbell, who has also been trained well. She's coming from the law reform perspective where you don't change something unless you know whether there's a problem and whether there is really a problem or not. Because you're not going to fix something that doesn't need to be fixed either. So I would suspect
fully agree with you.
Really we should get the information from, I would suspect though that it would be good to get the information from either the JCF or the JDF about what happened.
Well, the MLS has it here, Mark, and then if what was the rationale, Mr. Richards? Not hearing you. But SG, I agree with for many reasons, you know. One less value desk from my office to make an amendment. MLS, are you hearing?
Sorry, Minister, I didn't realize I was muted. Could you just repeat the question for me?
They're asking the rationale for asking for the change in 18.5 for that the visit shall be recorded in a registry, but there is no prescribed format for the registry for the recording. Is there a challenge? Is there lack of what is the ambiguity? What are you correcting?
So I understand that the reports that come up don't normally have the type of information in terms of who visited, the purpose of their visit, and so on.
And they're asking for it.
Right.
Who is asking for it, Chair?
The report goes to the Chief of Staff, who then takes to the Prime Minister.
Okay.
So I'd expect.
So what are those reports? What particulars are currently recorded? That question I don't think is answered.
Let me get back to you on that, Member Golin. Just have some further discussions with the JCF.
I don't remember the detail. There was some difference in the formats between the JCF and the JDF and between the zones in terms of the specific details. But again, square bracket and get back to us for next meeting. So we have the specific mischief to be corrected. All right.
Also, Minister, it's important that we get some consistency in whatever form of reporting we do.
In
so
fact,
that when
yes, I recall.
When they get back to us, they could take that into account.
You made that comment. You did make that comment, in fact, in some of the reports we got when we were doing the review, that different reports seem to have not necessarily contradict, but were not consistent in terms of what they're saying. And $20, registration of weapons. The recommendation from MNS to ensure that all the firearms are marked with Government of Jamaica marking standards be introduced in the Act section as is being proposed in the Firearms Act. This seems to be a common sense thing to keep the identity, but all of them have ballistics print. But that's not that the other recommendation is not about it. Am I right, Mr. Richards? Sir Richards, you're muted again.
Sorry, that's correct, Minister.
Yes, so all the government firearms have ballistics print, so that's not necessarily about, but all the markings should be standardized, so we are sure, and they do have the caps to do it very easily. We have laser markers now, so it shouldn't be a problem, right? So that recommendation, but does it act have to be amended? Does that require an amendment? It's administrative, so.
Mandate, the marking.
Yeah.
Good point made by the Office of the Public Defender.
So is that valid? All the government vehicles, all government firearms have a ballistic signature.
And I'm asking the question, Chairman, what currently mandates that?
What? The rules are for all government firearms have to get the ballistic signature out there. And you just establish the order.
So that's an administrative rule?
Yeah, well, I don't know what to call it. It's what I know. It's so established. I just know it as normal approach. No firearm is going to be issued to any member of the force before its ballistic signature is taken. That's what it is. What rules signature, I don't know. It's a normal thing, and it's there so long. I don't know what rules signatures signify, but that's what happens.
So section 20 is requiring that.
No, that's the laser mark. We have acquired laser markers to put what we call a Government of Jamaica marking standards. So all firearms that's a license in Jamaica in addition to what they call the ballistic, what Mr. Richard term used for the numbers and the firearm that you buy them with. We will in fact put a standardized laser marking on them on the Government of Jamaica side, like a license.
But if I may, Chair, the recommendation from MNS is speaking about provisions that are to come in an amendment to the Firearms Act, which we can't do that in law. So what I would propose is that what could happen is when that Firearms Amendment Act, that bill could propose a consequential amendment to the ZOSO Act when it is done. So whatever requirements are in the firearms law regarding marking, then it could then be, you can have a consequential amendment to the ZOSO Act.
Okay. Just to say for information, SG, that it's currently done for all licensed firearms, you know, as more as a administration to ensure we have a separate identification from the serial number for licensed firearms.
Understood,
Right.
Chair. But
No,
as
I'm just saying
Senator
this.
Campbell
No, I
is
accept,
saying,
I accept
since
you.
it's administrative and if it's going to go in the law, then we could do it at the time when we're making that amendment.
Accepted. No, she was asking about the ballistic. No, she was asking about it. She was asking about the ballistic signature. What law dictates? And I'm saying I couldn't tell you because it's just done. No firearm is issued with a ballistic signature recorded. What law they do it and the regulation don't know. No, they're two different things.
My question.
Yeah. So the first part.
I appreciate that they're two different things.
Yeah.
I appreciate that they're two different things, Chair. My question was under Section 20. The Section 20 requires the weapons and ammunition to be registered with the Institute of Forensic Science and Legal Medicine, which includes ballistic signature. And I appreciate the guidance from SG in relation to the amendments to the Firearms Act that are to come. I note, however, the penultimate line of Section 20, unless the Chief of Defense Staff or the Commissioner of Police determine otherwise. And I'm asking a question. Why would we make provision for a weapon not to be registered with the Institute of Forensic Science and Legal Medicine that is being used in a zone of special operation? I guess I'm asking for some clarity as to the rationale behind this provision.
No, read that for me at the end of Section 20. I don't have my.
At the end of Section 20, well, let me just read Section 20.
You break it up.
Staff or the Commissioner of Police determine otherwise.
You're going to have to read it again, Sharon, because you were breaking up badly. So you'd have to read it again. Read it again.
You're breaking up badly, Senator.
Let me read it.
I'm so sorry. Am I hearing it better now?
Okay, go ahead.
Yeah. God, again, if you have it there, Senator, help your colleague. So we're not hearing Senator Golding at all.
Let me read it first.
Senator Sinclair.
Weapons including ballistic signature and ammunition that are assigned to members of the joint force shall be registered with the Institute of Forensic Science and Legal Medicine prior to the conduct of operations within the zone, unless the Chief of Defense Staff or the Commissioner of Police determine otherwise. So I believe that the question being posed by Member Golden Campbell is, why is that proviso there unless the Chief of Defense Staff or the Commissioner of Police determine otherwise?
SGAG, we are in the drafting. We'll have to go back to the drafting of the legislation. I can see. The only thing I can see is that
part of the reason, though, is right now, as far as I understand it, it's an administrative process. So this proviso was there because you don't really have that legal requirement right now. And so there was some flexibility being given, but this proviso will not be a part of the new amendment to the Firearms Act, as far as I understand it. So I think this issue would be addressed, but perhaps the committee would want to make a recommendation about the proviso. And to be able to make that recommendation, you would really need to get some input from the JCF and the JDF.
Yeah. There's circumstances I could see of a JCF officer going to the zone in his division, wouldn't have required to could be assigned to do duty in there while in division, and he would not necessarily have to get his firearm registered with forensic medicine. There's a forensic fingerprint, so to speak. There's a ballistic print, as I said, for all of the firearms. But the special registration for normal policing, it will be tricky to get that done because once he's in the division, he can go in there and patrol anyway. So I suspect that the exception is put there to accommodate that kind of activity. But we could get the JSCF to give us some more explanation. In other words, in Mount Salem, the officer assigned to Mount Salem police here will have the right to go in the zone and patrol and apprehend if investigation leads him in that direction. But he's not assigned to the zone in a specific way.
Am I hearing you, Minister, saying that the failure to register, we ought to be received a report as to why they are not registered?
No. Some leverage, some leverage is given to the chief of staff and the commissioner to allow those who are not registered our firearm to be used in the area who is not registered. I'm saying, and it's explained the reason why the flexibility was given, that the law is an administrative process at this point in time. The new Firearms Act will prevent it from being an administrative process. But when it's administrative, you have to allow some flexibility. And I'm saying that the kind of situation that arise which would need the permission of the commissioner. If you assign someone from the division to do some work in there, he has the divisional commander have instances where the divisional police, who is not a member of the joint force, to go in there. And it's then he has to go in there and operate freely.
No, I understand that. The issue for me is it will appear that the joint command people, there's no registration of their firearm as required by Section 20.
No, they are registered, but there's a discretion given because it is not a law at this point in time. It's a regulation or administrative requirement under ZOSO. The new Firearms Act will not allow that. So some leverage by design. I don't know why. I'm just telling you, that's what you listed the SG. It said.
No, I'm coming, Minister, to where it says this should be done.
All the markings should be done because there's nothing requiring that. No, that's what's recommended. Ballistic signature all registered. It says in addition to requirement of capture ballistic signature. Every firearm, every policeman has, or JDF has a ballistic signature on record. And it's at the forensic lab.
So we're contradicting the response of the public defender. Is that what we're saying?
Well, I don't know if the public defender are here. You'd have to ask her.
Well, she reported to us in the committee that this was being done. It's captured in the matrix. And I want to be assured that her information is either incorrect or if it is correct, we need a sense of why after 3 years it hasn't been done. You're saying now that it's been done?
Chair, before you come in, can I just say something? Senator Brown, I'm a little concerned about how we capture this in and my recollection of that session with the public defender. There is no indication or suggestion that the weapons assigned were registered. Doesn't communicate to me that the no indication or suggestion is not just a function of the public defender not being able to get that information. I don't know that I do so because of my experience in that particular session of the Joint Select Committee. Not sure if I'm being heard.
I hear you now, but you weren't heard clearly, Senator Golding. Your internet gives us a little problem. Repeat what you had to say. You said in that session.
It seemed to be. And I'm saying, Chair, that I'm not sure that we can draw the conclusion that no weapons or ammunition were registered, because I don't think that is what is communicated by the not a recommendation, an observation in this matrix. So I would be careful that we're drawing that conclusion in circumstances where it may have been that the public defender at the time did not have that information there.
And all I'm asking for, since there's uncertainty, is whether or not we can get a report indicating whether Section 20 has been complied with in the main, or it is being honored in the breach.
Okay, we can check on that too. That shouldn't take long. All right. To recheck that, to confirm that.
What the issue is at this present moment in time is that there is no proposal to amend the provision that the section that exists.
No, the section remains as is from an information point of view. Well, clarify with Senator Brown his interpretation of the public defender's observation. Mr. Richard, we can check that and we'll inform the committee.
Okay, Minister, will do.
Established by Section 23.
Are you skipping 21, Minister?
21, yeah. Oh, due to those identity and requests. All right.
I mean, I don't mind you skipping it, though. Because it doesn't get my support.
I think, but I didn't hear what you said, Senator Brown. The recommendation from the JDF is getting your support?
Absolutely no. I'm saying it doesn't get my support.
You went off a bit because I was a little surprised.
Yeah, I don't want to surprise you today, my friend, Senator Sinclair. But it can't get my support.
And it doesn't get mine either.
Good.
All right, established with the Social Division Committee.
The recommendation was as to the makeup of the committee, I suspect, primarily.
Yeah, right. No, but the committee has all of these people already. We have it, unless they're not all in a relevance, you pick from all of these. Remember the new the Social Intervention Committee flows from all the permanent secretaries, which is the Business Council, all permanent secretaries, and the head of HEART, JSF, and HOPE. And then the ministry slid down the line.
If I may, though, Chair, I think the proposal from the Police Federation is to amend the first schedule to specifically include the child, well, it's CPFSA, I think, and the Children's Advocate, because they are not specifically referenced in the list that is already in the first schedule that goes from A to U. So it is true that the way how the provision is now crafted, you could have representatives from these organizations, but I think the proposal is to specifically reference these organizations. So that is what is being proposed and put to the committee for consideration. I think it's CPFSA. I think it's the new term.
Yeah, that's education has a big delegation there, and I don't know if it is necessary to define it, but I'll be guided. I mean,
Also, you says any other person who or agency that, in the opinion of the minister, can assist the work of the committee. So there is that provision as well. But
yeah, I said
that wasn't. The Federation has made a proposal, so.
They will look at the UN recommendation on the other side as well. Funding are being recommended.
Sorry, but before you go to the UN, the Police Federation had another point, which was that the committee should be, I guess, required under law to report to the Parliament quarterly.
No, the
so
reports,
that was another proposal.
We are currently reporting, and it will involve all of the reports on the SI. That's what we report to Parliament. We do it every 60 days now, and recommendations, we may increase that to quarterly, the time, but the report is being done. That's not. The child development.
Just that, Chair, the 60-day report is done by the minister. This proposal is for the committee.
No, well, it is.
Also do a report. So it's just that they're asking for something additional.
I don't think that's necessary. No, you're getting the full report from the minister. Just takes a report from the SI committee. To do another report by SI committee is a little bit. It is the executive responsible for the administration. I will support this. The child development agency maybe should be considered because of the specific need, the focus on the children. Whether it's within administratively or that they should be specifically involved. The children advocate is required to monitor these anyway. So I don't know, you want to put them on, whether it is the best place to put them on the committee or have her independently monitor it. But a regulator should be involved in the implementation committee. They should be looking on and checking if we're doing what is right. But again, this is administrative. Where you say it's put in Schedule 1, if you put in the law, you don't want to take the Children Development, the Child Protection Division.
And just to ensure that we don't miss it, because it's not actually in the matrix, but Social Intervention Committee, we had agreed would be changed to Social Transformation Committee. Was that?
Yes.
Yes, we had agreed to that, yeah.
Are you pushing through to the close, Minister?
Well, we'll try and finish that. I don't think we can close it off today. I don't think we need more than one more session to close it, but we are going all the way to, let me see how many divisions we have left. It's 5 o'clock. And I'm heading west, let me see now, 24, we go towards. But we have to look at the schedules. Doesn't look too long. But then, is there anything controversial coming up? This takes 23. It's 5 o'clock. SG, I'd recommend we take the representative of child development agents. The child protection is a specific thing. I don't take any other federation recommendation. The children advocates is so nice, but she should monitor externally. She has independent oversight body, really. Right. The UN issue, anybody thoughts on that, Senator Golding, etc. I don't think it's a bad recommendation, but I don't think the rationale for it is correct. Right?
But can we have the reports being sensitive to these issues, the reports that come to the Parliament and to the
the violence issue, the violence against women. I say I accept the recommendation that the first part, but I don't accept the rationale because the higher level of violence, as indicated, is the sensitivity of it. I support it to keep focus on it. It's most brutal and obnoxious, but the prevalence is against boys. High prevalence. Young men slaughtering young men. And European, Eurocentric organization to ignore that because it's principally the slaughter of men against men is principally associated with poor developing countries, heavily urbanized areas, and the black population of the inner cities of North America. Right.
Yeah, Minister, but I don't think you want to put one against the other.
That's what I'm saying. I accept it is a value to have the report, recognize them, and I definitely want to see it in there, but I don't accept their privilege. The second point that there are reasons for doing it. Right? I'm keeping my position on that vocal. The irrational, I think, is not the same as mine.
Once you go into the same journey, and
no, not quite the same journey. I have to carry the other one with me. I work on a broader road than they are. It's a serious issue, you know.
No, it is, and this is why.
Yeah, that's it. That's serious. The attitude of the developed countries towards violence among men, young men, especially young black men, is a serious issue, which is not given enough focus in the gender studies in the academic field, which is why it has become so persistent, and there are very few people who approach it objectively. I mean, whatever one, Professor Gale, who was undertaking it, and I had to work in both Europe and North America, because there are very few people there who take the matter that seriously. And it's young males in poverty-stricken areas, but it particularly impacts on young black males in developing society and in North American cities. 90% of the violence every time, and they slaughter each other daily.
Minister, you say you take us up to 23, because I'm kind of hearing in my ears saying it's a convenient. Did I hear her say it's a convenient time? Asked if it was a convenient time. She did so well the last time on that one.
Senator, I will give you time after the Senator. Since you're not the MP, I'm not sure you're exempted after the curfew hours, so that this minister will make sure you get exemption to stay after 9:30. Stay after 9. Yeah, my friend.
I think the exemption is all parliamentarians, so I'm cool.
I'd have to ask JSC to advise me on that. The MP is exempt going to his work. If he's caught doing anything else, he can also be charged. Which is why.
Well, since the Senate meets tomorrow, I'm nearer to doing the Senate work than
that's why I maybe want to keep you a little longer, so you don't have to do much work. You won't have to edit too much work tomorrow in the Senate. You'll take a little break, a little breather, and allow the others to go.
No, Charlie and I will go to the Senate.
My bill is coming there.
The Senate now allows us to go virtually, so we can, Charlie and I can choose not to attend in person tomorrow.
I hear you, sir.
Sorry, Chair, if we can just get the decision on 23, and then in my role as almost nearly trade union leader for the technical team, then I would ask if it's a convenient time.
You know, that's a powerful trade union.
Yes,
Lambert,
CPC, please do not.
SGQC, head of the trade union legal advocate. My God, boy. I cannot negotiate.
When the Queen wants to speak, we have to listen keenly.
They did. But is that a negotiating position? Is that instruction?
But Chairman, I must advise you, that those practices they are one of the SG from a long time ago.
Thank you, Member Jackson. That's all. Thank you.
I have been on the other side of the table.
I hear you. You're just reinforcing our position. I know I'm saying this the second schedule in terms of 23 recommend that we accept to name the child protection again more for the level of importance it carries to deal with the children to reinforce that position and leave the others out. Because I don't think, and in the second phase, we insist, it sounds more like an administrative recommendation, but the reports must pay specific attention to the violence against women and family violence. Let me get it clear what it says there. Yeah, I'm accepting a recommendation for someone to be designated who pays attention to family violence. The police has trained many officers and therefore can name someone to that section. So accepting that recommendation.
So that would be an additional person added to the list.
Yeah, and it's it's not an additional person, a member of the joint force should be so trained and designated.
Well, that's the first focal point. I was also looking at the social intervention committee.
Yeah, the scheduling. We take the child protection and
but not violence against, because they're also asking that the social intervention committee have a specific person from who represents a group.
So the joint force include a focal point on gender-based violence. So that would be adequate to deal with that, and the report reflects that. Right.
Okay.
So it's one of the joint force. It would be one of the officers who have been trained in this kind of activity by the police. And if we're near a station with the intervention center, fine. We take. No, we accept that. I was just saying that I'm not accepting the rationale. And I had a discussion with my center colleague of a Eurocentric opinion. Okay, you want to take the break now? We could push on.
Is it a convenient time, Chair?
I think so, because what's left will only need one session, but it would give us enough time to have a discussion at least. If we rush it through now, we're just going to lock off kind of sharply. And it'll be a little bit tight. It's 24. You have all the way to, and we have the schedule to look at. And we go as far as 20. Oh, wait, no. 24 is only one night. No, we have the schedule along here. It's 5 o'clock. It's a convenient time. You suggest we take the break and we just have one more session to tie up what we have done and look at the minutes of the meetings to see that our decisions were properly recorded.
And Chair, we also need to go through the wording for 12, which I was providing. I sent a draft to MNS and I'm just awaiting their input on
it. All right, we'll take a break now. Let me thank everyone for coming and for your support in getting this bill through. We're going to we'll take it through. I think maybe one more session, a good session, should get this through. If certainly not more than 2 sessions. But let me thank everyone this evening. Have a good evening. And Mr. Brown, you have a good time in the Senate tomorrow. Yeah.
Well, your bill is on.
Senate. Yes, my bill is on, and Senator Sinclair is coming from Montego Bay. The Senate is based in Kingston. We accept that. That's one of the few good things in the eastern part of this, in the eastern city. So you treat Senator Sinclair as a distinguished visitor. Senator Brown?
Yes, and I'm sure the standing orders will change one day because he's on the standing orders committee to allow us to move from Garden House to the conference center in Mobile.
It's not a bad thought, but we may have to have one like a republic government, a federation next time around rather than move you down there. Yes, we have to consider that aspect of the development.
They will not give up the national for the regional.
National, no, that's when he'll become the national president. we'll have the casting votes, remember?
Wow. It requires a tie to have the casting vote. But I agree, it's a convenient time, Minister. Ladies have a lot to do other than what they're doing here. And we have some other things to do too.
All right. I'll do again. Senator Brown is casting, giving reason for the ladies have longer staying power than you. They'll stay here and finish this thing because they want to get it.
That's true too, but I know they have compassion and they have a lot to care for.
All right, they'll accept that they have some compassion, Senator Brown. We adjourn. Thank you all very much. Have a good evening. The Senate, have a good day in the Senate tomorrow. Senator Golding, have a good evening.
Sorry, Minister, before we go,
when is next meeting settled?
The 15th of July, sir.
Yeah, you're asking, and Ms. McCarthy?
Yes, sir. The next date that we have available is the 15th of July.
Okay. July?
Yes, sir. I'd gotten some dates from your office in terms of your schedule, but the 8th is gone.
15th of July or June?
July, sir. June is completely booked already for the committees. The closest date I'd gotten, it's July 8th. But
what? Availability, space, my diary?
Your diary says July 8th is no longer available unless you want to ask somebody else to chair. But saving for if that's not possible for somebody else to chair on the 8th, then the next meeting is July 15th.
We're in June,
I know, sir. The schedule is full for June already. It's full from
May. What days you can?
That's what I tried to do, sir.
In the 8th and the 15th, and whatever else you can lock off, I will communicate.
The 8th, you're not available. You're not available.
I look at my diary and see what's available before, if any at all. All right? Well,
June is completely booked.
Could we consider not on a Thursday?
Mr. Jackson?
Yes.
And Thursday is inconvenient to you?
I'm trying to avoid the Thursdays. Those are, for those of us, many of us, that's our constituency days.
Right.
You don't have to go to the constituency further right now. You don't give dictation and all kind of things rolled by you.
My representation and role is not only close to election time in a chairman.
No, we know you're represented in many ways, including not time. You're a powerful representative, as your boss said a while ago,
So DPM, how many more meetings do we need to complete?
I don't think we have more than 2 at maximum. We may do it in 1. If we take
Never drive under the influence. It's essential to avoid operating a vehicle